Welcome back to CEO Money. I'm Michael Yorba. Thanks for joining us. All right, this segment we've got Blake Beckham of the Beckham Group on the show with us. Blake, welcome to the show.
Thank you, Michael.
All right, my pleasure. All right, today we're going to talk about trial at the courthouse, right?
Well, trials at the courthouse and other types of commercial litigation.
All right. Typically, what's it usually take to really get your answer out of this?
Well, if you look at litigation, that's going to be made up of trials at the courthouse. You might have state court or federal court trial. I want to also talk about arbitrations. People have questions about mediations and other types of alternative dispute resolution, and that's called ADR. But let's start with a trial at the courthouse. You know, if you're involved in litigation, at some point your lawyers are going to come to you and say, do you want to go to a jury trial or go to a judge trial, a bench trial? Bench trials typically quicker, but if you have sympathetic elements to your case, if you're trying to pop somebody for big damages, you may well want to go through a jury trial. It takes longer, more expensive. There's also choices at the very beginning of the case, whether you're going to be in state court or federal court. And those types of decisions are made based on the claims that are brought. Sometimes if you're suing somebody from out of state, you're going to get up in federal court. But if you get with a good litigator, you work through these issues, there's strategy points for all of them. But the one thing with the trial at the courthouse is you may run into appeals. Michael, have you ever had any experience with appeals or understand how those go?
Absolutely not, and thank God so far. But go ahead.
Well, they can take a long time. It's interesting. You prepare an enormous amount for an appeal. You write long papers, which are ironically called briefs, which doesn't make any sense. You do all this work, and you go before a panel of judges, and you have 20 minutes to present your side. Then you may wait 9 months for them to make a decision. So it's kind of an antiquated process, and the long periods don't make sense to most people. But, appeals court can take a good trial away from you. And that's one reason people look at arbitrations, and they think they're less expensive. Sometimes they are, sometimes they're not. But an arbitration is a contractual arrangement where both sides agree our dispute is not going to be at the courthouse. It's going to be arbitration, which number one is private, which number two typically cannot be appealed at all. Therefore, the overall duration is shorter. The arbitrator, or sometimes there's three, the panel, kind of works at your convenience, and so it's easier to have hearings along the way. You can keep a case moving. Now, some of the disadvantages to arbitrations, people think, well, an arbitrator, they split the baby. They find a middle ground. It's harder for them to make a tough decision and either give one side a complete win or pour the other side out if somebody needs to lose. Arbitrators don't necessarily have to follow the law. Sometimes their emotions or their personal perspectives color cases, and you can't appeal them. So that could be good if you win, but if you lost and you had a significant loss and there's really no way to appeal, you can be stuck with it. Now, people think arbitrations are cheaper because perhaps they don't last quite as long. But there have been several organizations. You may have heard of the AAA, the American Arbitration Association. There are organizations that run the arbitration. And when you're in an arbitration, you have to pay the hourly rate of the arbitrators, or perhaps you're splitting it with the other side. But if you got three arbitrators, they're all senior experienced lawyers, so you're paying three lawyers plus the organization that runs them. The courthouse is free. We don't pay the judge. You pay a $200 or $300 filing fee on the case, and that's it. But the filing fees can run in the tens and hundreds of thousands of dollars sometimes on arbitrations. So they can be expensive. Sometimes big companies utilize arbitration provisions when they're dealing with smaller companies or ordinary people as a way to kind of box them out. Oh, if you're going to arbitrate, it's got to be in New York City, and the filing fee's $10,000. Well, how's that going to work? And it doesn't for most people. So if you're a businessman, if you're looking at a contract with another company and there's arbitration provisions in it, you really need to get some advice on what that means, what might that cost. Are there ways to structure arbitrations that are more inexpensive? Are there pitfalls? But don't just blindly sign an arbitration agreement thinking, oh, this will be good for everybody.
What about if you're franchisee or franchisor?
Well, that's a good point. There's several types of industries. For example, franchise. I represent some people that own Meineke franchises, and in their contracts, the owner of Meineke puts in very stringent arbitration proceedings that are heavily favored against the franchisee. So if you're getting into a franchise business, you're going to have to understand I'm probably going to have to play in their ballpark, and I'm going to have to play. A stockbroker is the same thing. If you sign a contract with a stockbroker, you may be having, if the stockbroker churns or does a bad job and you want to have a case against him, you may be sitting in front of a panel of stockbrokers that perhaps may be jaded against public claims. So the public really needs to understand what they're signing when they get into arbitration, because they do sign away a lot of their rights.
Blake, we've only got about a minute left. What about the mediations and other ADRs?
Sure. Well, mediations are very important in all of these they're non-binding. It's a settlement conference, but you've got an experienced lawyer, typically a former judge or a very senior attorney, that digs in and gets to the bottom of both sides and helps mediate, helps do shuttle diplomacy back and forth to try to get a case resolved. It's not a binding resolution like a trial or an arbitration, but the vast majority in cases that go to mediation are settled. So that's always a good idea.
Okay. Last thoughts, summary jury trials or private trials before we close out?
Sure. There are ways to be creative, and if you have a good litigator, you can get creative. But a judge in Texas will allow you to go down and pick a jury, and you have a private trial with the other side for the purposes of settling. They might give you a 6-member jury, and it's a summary. It's a day or two long, but it's a preview. And that's a very creative way to get a difficult case settled, is go in and do this mini trial in front of a small jury and then try to settle. It's not binding. It's a type of ADR, a type of mediation, but not everybody wants to pay to go all the way through.
Blake, we got to go, but thanks for being a guest on the show. Can't wait to talk to you again.
Michael, thank you.
You're welcome. Blake Beckham, the Beckham Law Group you've been listening to, CEO Money. We'll talk to you again. Thanks for joining.